This is the level of conversation that we're going to be looking for, by the way, in this seminar. It is designed, this PowerPoint, this seminar. We've done this a few times over the years, and designed to inspire discussion. And we would very much like all of you to pitch in and talk about your experiences, ask questions. This is it's a roundtable discussion. It's designed to be, and so please help us through this last hour of programming. Tripartite relationship. Not yet. Tripartite relationship and the ethical rules and the interplay between those two principal documents that we all deal with. So I'm Rick Rigai Fitch, Phoenix. Next to me is
Henry Ahosa, Senior Vice President with National Chem Services.
one very brave lady.
Yes, and thank you for joining us. Much better. It would have been just Rick and I, that would have been bad for everyone. And Jimmy Orland, Portland Law Group out in California.
So Henry was kind enough to jump in last minute here to help us with this presentation, so we do want to thank you, Henry. And Henry's really the perfect person to join the discussion here and give us the carrier perspective on the interplay between litigation guidelines, which we have all come to know and love, its standard of care in the industry, and the ethical rules of conduct. And a lot of times, folks on both sides of this relationship don't appreciate the ethical rules that come into play when we're trying to provide service and comply with the ethical guidelines. So we want to talk about those things today. So as I was mentioning, the standard of care in the industry for carriers now requires the implementation and enforcement of litigation guidelines. Not only guidelines, but third-party bill review and management. On the other side of the equation, lawyers are governed by the moral rules of professional conduct, and I italicize the word rules because they are rules. They're mandatory rules for lawyers. And so the question becomes, are the guidelines being enforced with enough sensitivity to the ethical rules? And I think it's also important for us to mention here that this discussion is not designed to be adversarial. These are potentially sensitive topics, right? This goes to the core of the relationship that we all have together. This is meant to tee up some of these issues, educate those that don't think about the ethical rules and their interplay with the guidelines, and inspire some conversation. So I promised Henry that would be the format today. And she, of course, was gracious to join us. So
I guess they're setting the mood.
All right, thanks, Judge. But how do we tackle this sea change? Where do we see this? Bill sharing, bill auditing, regulation of legal tasks, increased pressure on the tripartite relationship, and there's a question mark there. This setup is not new, right? This has been the way our relationship works with carriers and our, sort of captive clients, so to speak, for a long time. The recency of the academic litigation guidelines and third-party bill review has changed things dramatically and objectively. And so, does it increase the pressure on the tripartite relationship in general? Jimmy, yes or no, sir?
Yes.
Henry, what do you think?
I mean, certainly it can. But I think that there are obvious reasons that we can all accept that it's important. I mean, our insurance expect it, frankly. I mean, we'll have agents and brokers ask us, don't you have a third party that reviews these bills, that audits? I mean, they expect it. And we have a duty to our insurers to find ways to resolve cases, protect their insurance dollars as best we can, because it impacts them later and impacts others in their same class. So we have to apply some rules to impact that.
What about a concern about potential, privilege waivers? When you have, a lot of these bills, if you're not very descriptive about what you're doing, they're going to maybe audit or do a deduction. So I think it encourages us to be very descriptive in our billing, and you can go very descriptive and maybe there's some privileged discussion in there that somebody can see at some point.
So, perfect segue into what rules are we talking about? So the ethical rules of conduct, which are similar across the board, across the country, call into question the rules on competence, diligence, communication, confidentiality, which Jimmy is touching on, conflicts, evaluation for use by third persons, and unauthorized practice of law. So the first real segue here is into competence. So Rule 1.1, which is similar, like I said, across the country for lawyers, is that a lawyer shall provide competent representation to a client. Shall provide competent representation. That requires legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So when you read this language, what are you thinking about? You're thinking about litigation guidelines and some of the restrictions that we see in them on the amount of work we can do and which professional can, perform or should perform those tasks. And the comment to this rule, you can read there, says, competence includes inquiry into an analysis of the factual and legal elements of the problem and the use of methods and procedures meeting the standard of competent practitioners. So we've got some pretty vague language that lawyers like to use. And it does permit, the ethical rules permit reasonable limitations on the representation, but they have to be reasonable under the circumstances. So what the hell does that mean? Jimmy, what do you think when you think of being able to competently represent a client in light of your experience with these litigation guidelines?
For all of us firms and associates, I think the first thing is, we have to monitor, supervise, and constantly meet with our younger associates to make sure they're doing the job, that they're, representing the clients. So that's number one. I urge everyone, and I'm sure you all do, the attorneys here, is to, weekly, if not, every 2 weeks, meet with your associates, go over all their cases in detail, make sure they're doing what needs to be done to protect the client. Because a lot of them just don't know. So it's really on us as senior partners, managing partners, to really oversee their work and make sure that not only are they defending the clients, but also complying with the guidelines.
show of hands, how many, and this is really directed to lawyers in the room, but how many of you like to get down into the weeds and review all the documents in your case, or as many as you can? Who likes to be in control of the information? Okay, we still have some old schoolers out there. So when I think of this rule, I think of how much time am I going to spend understanding my case, reviewing medical records, for instance. So,
It delves into some of the other ethical rules that we'll get into, in terms of paralegal work, but you could spend, if you want to aid a job in a summary judgment motion, for example, I mean, you could spend 30 hours on that, think or more, and then you run into the risk of getting time cut. So what I always tell my people is, just bill your time, I'll deal with it later. I don't want them to be limited in how much effort they're putting into a motion, or usually motions, by like potentially getting time cuts. I'll deal with that later. You guys just do the best job. I don't care how long it takes you. And then we have to deal with, if it's X amount of time over what some third party person is telling us it should have taken, right? That's one of the challenges.
right, and so the next slide talks about, it's Rule 1.3, diligence in
It wasn't you, Rick.
It's a lack of diligence. I thought it was something I said.
I think there's some Eagle and Chiefs fans in there. You guys exposing what happens behind the curtain.
There's shattered glass all over the floor back here. So we segue from competence into diligence. These two rules are similar. There's some different language, though, that we need to consider. And there's a shall term in 1.3. A lawyer shall act with reasonable diligence and promptness in representing a client. A lawyer should, this is in the comments, take whatever lawful and ethical measures are required to vindicate the client's cause. So, Henry, when we think about AI, for instance, and we've been talking about AI and the use of AI, and you think of the old school model where the attorney, whether it's the senior partner or at least the associate that's working on the case, is reviewing every document to understand, the details of the case. Well, now we have AI. So what's the expectation, do you think, in light of this black cloud that's hanging over our heads, the expectation for the use of AI versus lawyers actually doing the work themselves?
Sure. Certainly that's going to evolve over time. I mean, I don't know how to define yet what that correlation will be, right? So to your point about time and reasonableness of time, thousands of pages, if I know that AI could cut your time in half accurately, would I expect that? Probably, but I don't know how you define that at this point and how you set the guide, because I don't think we all know enough yet to know how much you can rely on that and not how much it does affect your time in actually completing those tasks. But certainly without question, it's going to make, being more efficient is going to make you more profitable, right? And then it's also going to make the process for us less expensive. So I think we're all aligned with the goal with that. And I don't think it hurts anyone for that to be a reasonable expectation that be utilized where appropriate.
I don't think anyone really enjoys reviewing thousands of medical records or documents, but I've won cases because I reviewed every document and found one nugget in there that literally won me a case. The plaintiff said he security guards hit him with a nightstick and broke his ankle. Found one note out of thousands of pages that said, from a physical therapist, fractured ankle playing basketball. And we started trial, and it didn't go well for him. So,
And that's what I have in mind.
right, you,
I mean, probably though, they can train AI to, is there another activity noted, right, to find something like that, so.
hopefully, but do you want to risk that?
And that's the question, isn't it? And what Jimmy is explaining here is what I have in mind when I ask this question, because, you know, most of you in the room are trial lawyers, and good ones. And that's the attraction to this group, right? Is that this is a group of folks that know how to try cases and actually try cases. Well, we all know that trial law is different than litigation. When you put a case under the microscope and you're, you know, arguing, setting up themes in front of the judge, jury, and God himself, you're you're expected to know and should know all the detail, and you find nuggets, you know, in the detail, in the thousands of pages of documents, whether they're medical records, construction documents, you name it. And so this is where we start thinking about AI and where is the cutoff, and where is the ethical cutoff to acting with diligence and with competence.
So, Rick, is AI going to be measured in an error rate against a zero standard, or is it going to be measured in an error rate compared to human error, right? Human error ranges somewhere between 4 and 6%. You know, Jimmy caught that one, but Jimmy could have easily, although unlikely, have missed it as well. But, you know, I mean, they just with humans involved in the process today, without AI, there's mistakes being made across the board, right? And the expectation of AI, from the conversations I've been involved with, is like, it has to be dead point accurate, you know, no chance of error, and things of that sort. And I don't know whether when it butts up against your standard or the legal standard, whether or not it's going to compare itself to human error rate versus absolute.
Well, if I'm being called on the carpet for an ethical violation, I'm going to argue that there's no difference, that there's error built into both, right? But when we think about these ethical rules, we're thinking about the plaintiff lawyers that like to accuse, and the same type of standard exists in the state bar. You know, the state who are prosecuting these ethical cases. But yeah, I don't know the answer either. There's error built into both.
Right, and understanding the same ethical obligations that you have, we have. I have a license too, right? Obviously not a bar, I passed the bar exam, but it's obviously we have that same ethical standard required of us as well. And, you know, certainly people are not shy from suing insurance carriers and accusing them of things, right? So I think we both have that same concern and duty that we owe.
Yeah.
I think Mark had a question.
Well, yeah, I have a question, a comment. You know, on your case example, Jimmy, I just literally yesterday got assigned to a case that come in at trials on March 17th. And the adjuster joked in the first email and said, hey, you know, thanks for jumping in, but you might want to, you know, think about it because there's 10,000 pages of medicals. Okay, does anybody really expect I'm going to look at 10,000 page medicals? And what if you do, and you don't find that golden nugget of a broken ankle? Is the insurance company going to really pay that? If you have qualified paralegals, they should be able to catch that. Junior associate, a senior attorney should probably review some of it. AI, I think, is probably going to be a fantastic calculus on that for a lot of reasons. If we could ever figure it out, lawyers will have to pick up new technology. everybody else is using it if we need to. But I ask the insurance companies, who's going to pay that? And you might catch it. 1 out of 10 attorneys might do that, Jimmy. You're one that would catch that, okay? 9 out of the other 10 might not catch it. But I'll
Plaintiff attorney certainly didn't, even know his own case or his records.
Well, you play basketball. So, my question is on the audit side too. What's reasonable? So I guess I take a look at it this way when you talk about reasonable approach to handling a case, highest and best use. Highest and best use for a senior partner that's going to come in and try the case is not to review the microscopic medical records. To have good quality help and steer you in the right direction, and then get really prepped up on it before trial. And you might get into the weeds at or right before trial, but reviewing 10,000 medical records beforehand, that's not a good use of my time.
No, I agree with that. I mean, you have to, it's case by case, I think. And you're certainly not, at this point of our careers, do we really want to even review 1,000 medical records or 500? I mean, we hope somebody who's doing it is going to be thorough and find everything that's important. But yeah, it's a balance, right? And I also, when we bill, no matter how many pages of documents, so these third-party billing auditors are, if you just say review and analyze, claims file, and job file for client, they're going to deduct that. You have to now review and analyze, claims file, job file, etc. 275 pages. Put those in parentheses. That way, that's what we're doing now, and it's working. They're not deducting time for they don't know what we did. It gets problematic when review and analyze 10,000 medical records. So what I would suggest is you call up the adjuster, pick up the phone, say, hey, I got trial coming up in 2 months. We're coming in. If you want me to handle this, this is what needs to be done. It's really up to you. You don't have to take the case, and they don't have to hire you. If you tell them, I think we need to do this to make sure we're vigorously representing the insured, you have a conversation, like call up Michael. Hey, Michael, what would you say, Michael, if he said, hey, I got 10,000 medical records in here? What would your response be?
He'd say no.
Really easy. I called you for a reason, right? I called you for a reason. I know this thing is being dumped on you in the last minute. Do what you need to do to get it done. Completely outside of normal parameters.
Yeah, the guidelines are not made for that situation.
No, that's not the kind
Right,
of case
yeah.
I'm talking about. I'm talking about
Yeah.
general case when you've got 10,000 medical records. It's still highest and best use.
Well, I think also depends on what's the injury. I mean, if it's a fractured ankle, come on, you figure it out. If it's, a traumatic brain injury, or if it's, something really bad, and there's questions on what caused the injury, a lot of times medical records can be gold. I mean, you can find stuff in there. It happens. I'm sure everyone here has a story about reviewing. Somebody says they tripped and fell in a bar, and then in ER they said, "Oh, fell down the stairs." Right? I'm sure everyone has those stories. So I think it depends on. I think it's a case-by-case basis.
No question. But the thing is, when you talk about these records, what do we normally do when you get that situation? You look at your admission and your final discharge. That's where you kind of look at it. But relying, though, as you said, with possible AI, that's where the danger comes in. AI should be a supplement, not to do the job. And that's the critical conundrum we're all going to face. You're faced with expense crunches. Do I use that to save me? But when those medicals come in, as you said, it's a case-by-case basis. You got to go in. Now, if you happen to get sued by your carrier because you missed one note, well, then there's other problems there. That's just crazy. But it's a case-by-case basis. You got to be very careful. But again, you look at initial summary, discharge. Everything else in between. Are you ever going to look at a normal case? $1,000-page ER. A hospitalization? Probably not. Because it's got all the meds, and all the drugs. You're looking at certain things that we've been doing for years. Doesn't supplement and stop you doing that.
On the case I was referencing, I had a sense that there was something off after his deposition. I just had a feeling there was something there. So that's kind of why I myself reviewed it and I found something. You know, you just have an odd sense that there was something there. So, but I agree with you, you know, it's case by case basis. And there are certain sections that you always look at, especially, you know, you always want to look at the ER report and discharge. But I found my thing like buried in this thing. It was a one-page note, and I called the physical therapist and I subpoenaed her to trial. And, you know, it could save your insured, and their demand was like, I don't know, $600,000 or something. So, you know, it saved them a lot of money.
Consider that case closed. All right, so we're gonna move on to talk about communication.
Hey, Rick, I'm sorry, I told you to
Mark.
jump earlier. I apologize, I have to leave to catch my flight, but I have a question. It's probably jumping ahead a little bit, but I'm dying to know this, especially with this audience, both carriers and attorneys. There's been a lot of discussion over the years about the ethics of submitting our bills to third-party auditors and whether we might reveal confidentiality, okay? And we do a lot of work with real high stakes litigation where there's coverage issues, and we're defending. And the issue is whether, you know, are you exposing your client to issues related to coverage if you're very descriptive in your billing entries? I have not had a problem with that. I haven't seen any problem with that. My question is, are any of the carriers here actually using information like that in coverage? I haven't seen that on the coverage side either. And are any attorneys, more importantly, has anybody come across a situation where you are being accused by maybe the personal counsel or private counsel or somebody else for breaching confidentiality in your billing entries that go to a third-party auditor? Does my question make sense?
Yeah, and so you're a couple of slides ahead.
Yeah, I'm sorry. I believe right after the answer something.
No, it's a great question, and let's just talk about it. So there's a few things involved. There's more than just one rule that's implicated by this. Confidentiality, of course, and evaluation for use by third persons. So Rule 2.3 talks about providing information to a third party, essentially. All right. A lawyer may provide an evaluation of a matter affecting a client for the use of someone other than the client if the lawyer reasonably believes, there's that term again, that making the evaluation is compatible with other aspects of the lawyer's relationship with the client. So the rules contemplate this, they provide for this, and as long as the client has informed consent, you see down in subsection D, it talks about informed consent, then the lawyer shouldn't have an ethical problem sending evaluation letters, for instance, to a carrier that's paying you on behalf of your client. Now, the problem, you know, arises, and there's more to this, confidentiality in billing, for instance, and that's something that probably should be the next slide here, but it's a little bit later when we're talking about bill sharing. Let me get to that too, so we can talk about both.
Let me ask you a question, Rick. So let's say you prepare, you know, status report to carrier, you know, let's say 1.2, and then the bill reviewer says, I need to see a copy of this so I can make sure it's a reasonable amount of time. You have your evaluations in there. I mean, is that a concern? When the bill reviewer is asking for your status report, where you're giving your liability evaluation and analysis.
The rule is confidentiality. That's the rule that's implicated here. And we saw the rule earlier and the buzzwords that, you know, govern the rule. So yes, it is technically publishing confidential information by rule. And the first the, and, should, may, that you communicate to a third party is you are publishing information that is privileged. So where does it become an issue? Is it the evaluation itself?
call it a carrier.
Yeah, that's exactly right. Yeah, I mean, no carrier's gonna ask you to break confidentiality. I mean, that's
If someone's-
easy enough. That's so easy to solve.
Any document,
Yeah,
Yeah.
post documents, if that's happening, you need to call.
absolutely.
Yeah, but Rick, here, and then I promise something. Has anybody here had a problem where they submitted a report or a bill and had that to bite their client on the coverage side or anything related to that? Because
I've never heard of that happen, or just for the record, I've never heard of a bill used for coverage.
or a report letter though, a status report.
I mean, I'm sure that has possibly happened somewhere, sometime, right? But a bill, no, I've never heard of that happening, personally.
There's an unnamed carrier that I don't think they write anymore. I'm not gonna name the carrier, but they used to mandate for construction defect case, what's the defect, what's the resultant damage for each defect. And it put us in a very various position. It made, I think Rick and I shared that carrier, made us very uncomfortable.
Yeah, that would be a problem. Yeah.
That was a
Should not be
difficult,
requesting that.
that was a difficult relationship to manage.
Further to Mark's comment about has anyone had a situation with not just billing, but a report where there was some information that may compromise the coverage. I had a very large case one time where I had to send all my reports to personal counsel for his review and approval prior to sending to carrier, and I'm sure I'm not alone in that. But at one point, this personal counsel said, you're gonna take this part out. And it was some critical facts that I thought not only I understood how it may affect coverage, but it could provide for a dispositive motion as well. But the personal counsel's like, I'm not taking a chance, you're gonna take that out. And then in a tripartite relationship, you know, we were in a conflict scenario at that point because it was such a good fact that we decided we're out and had to report to the carrier, you're smart people, you're gonna figure out why I'm telling you I have a conflict. Maybe you want to hire your own lawyers to figure out some of these facts, but I have an ethical obligation to withdraw. And we did.
Following along to that, Gary, I had a similar situation, this is a long time ago, and it was also in a construction defect case. It's one of the few times in my career I fired a client. It was a very large case, very large client.
This was also a construction defect.
Their personal counsel changed the sentence in my status report letter and wanted me to say something that was the opposite of what I thought and what I believed. And obviously I couldn't do that, and they wouldn't let me send it without saying it the way I was going to say it. So basically they wanted me to lie. And I said, no, you're gone. I'm withdrawing. And the insurance company was left wondering why the hell I withdrew. So that's a little warning to insurance companies. If your counsel all of a sudden withdraws, you might, that might be what's going on. So.
Yeah, it can, this issue comes up, it can become, you know, a very big issue. You're right. We should be smart enough to read between the lines to figure out, you know, there's a reason this happened, right? I know I have a case right now where there's a sincere issue of the insured wanting to sabotage the case. And we're intervening to ensure that certain evidence that we know exists does get displayed and, you know, does go to trial. So, I mean, there are ways to get involved in that.
Yeah, intervention though, so rare, very seldom range, as you know. Are you committed, you know, for filing a separate action? That's what I really think happened.
Right. Absolutely, in this case.
What happens to this tripart relationship when there's an intervention? Let's say your client's out of business, bankrupt, whatever, and the carrier intervenes. It happens a lot in California. What do you think about your tripartite relationship at that point?
Well, to start the conversation off, the carrier, I would expect the carrier to have, you know, multiple adjusters to wall them off, right? So that you're only dealing with the adjuster that is handling the defense of your client. So this is not uncommon, right? So you have coverage counsel filing a deck action, they're dealing with somebody else. And so there's a discrete, line between the two, and nor shall the two meet. And that seems to work just fine. And in fact, and getting back to the ethical rules, we're talking about conflicts here too. I like having a strong coverage attorney involved in the case, because we can play good cop, bad cop. I can point to coverage counsel. If they have a strong enough opinion of their policy that there's no coverage, that they are willing to file a deck action, now I have some real leverage. I can play those cards without playing those cards. I can just point my finger and send them to the next room. And that tends to work on plaintiff counsel. It's the best leverage there is, frankly, because that's where the money is, right? So, anyone disagree with that?
I just had another thought. Years ago, it hasn't happened recently, but it was an auto carrier, one auto carrier, and I had a good relationship with them. And I sent them a report and said, it's got some serious excess exposure to the policy. He sent the letter back and said, never want to see that writing. I understand it. If you go to trial and you did it, go to the policy, I'll pay it. That's all verbal. It's settled. That was professional.
That is a great question/comment. What do you do with that? What do you do with that? When nod, nod, wink, wink, we know each other, you trust me, I'll pay an excess verdict if you get hit. Nothing's in writing. Do you, as an attorney now, to comply with the ethical rules, is it your obligation to get that in writing, or can you just move along with the trust law?
Yeah.
Yeah.
Simple, right?
What about the first part, though, the recommendation to settle the case within the policy?
Recommendation to
Audience?
settle the policy?
No, you said it. I thought Jen said it.
I did, so I said, just have a conversation. My client is the insurer, right? It's not the carrier.
Yeah.
So I said, look, there's an excess exposure that's coming out of my client's personal accident, right? So I think you should settle. We didn't lose. Sure.
I think generally speaking, it's from an insurance carrier perspective. I don't want to just read that in an email or a report. You should be picking up the phone and having the conversation. Frankly, even, having the conversation where the insured and, maybe we're all on the same call together and all heard the same information. Just don't want to be blindsided with that information is generally what the rule should be. I realize there are sometimes adjusters who probably take that a little too far. There's exceptions to every rule, of course.
Yeah, I think a lot of it is in the messaging. And I'm sure you, if you were to put that in writing, you would have a conversation first, right? So this is coming. I'm duty bound to send this letter to you in compliance with the ethical rules. So, and I haven't had a problem with that as long as I have a conversation with the carrier and let them know why. I don't recall a time that I've had pushback or adverse, effect on the relationship. So, conflicts. The conflict rule is long. There's multiple parts to it. There's interplay with all of the concepts that we're talking about with the conflict rule. And when we talk about the tripartite relationship, we talk about being paid by a third party to represent our client. We are talking about the conflict rules. They underlie the relationship. So, in addition to the other rules we've been talking about. So, Rule 1.7, a lawyer shall not represent a client if representation involves a concurrent conflict of interest. So, you know, that really relates to two clients, right? So a concurrent conflict of interest can exist if the lawyer reasonably believes that he or she will be able to provide competent and diligent representation to each affected client. So the question to all of you is, who is the client? Is it the party on the paper, on the caption, or is it the carrier, or is it both? What is this rule talking about? Anyone? Bueller? Voodoo economics?
Risk action. Go to great lengths, especially when I'm working with our younger lawyers, to stress that the client is the entity or the person that we have been retained to represent. And I actually get pretty, I'm a stickler on the terminology. I don't really like it, but we're, you know, in our office, people are referring to our clients as the insured.
I don't like when attorneys do that either, actually.
No, they are a client. And in the Tripartite case, for example, when we, you know, get the assignment, then the very first thing we try to do within a day or immediately is get the truck driver on the phone and immediately explain to the truck driver that he or she is our client. We're going to take by the insurance company, but we do not represent the insurance company. So that's just an act.
That's right. And that's the way that I view the ethical rule too. When they talk about a client, they mean your client, not the carrier. However, I do believe that there is a secondary client relationship with the carrier. I mean, we have obligations to report, communicate, and to my mind, to collaborate, you know, with the carrier because they're paying for the defense. And so these ethical rules do come into play to govern the relationship between us and the carrier. But obviously the primary duty and the primary enforcement of these rules is going to relate to the client. Now, it calls then into question Rule 1.8. And this gets back to, you know, communication essentially. It's kind of a combination of the two, but a lawyer shall not accept compensation for representing a client from one other than the client unless, and this is the key subsection, there is no interference with the lawyer's independence of professional judgment or with the client-lawyer relationship. And that's something that, this rule kind of inspired this PowerPoint because it's something that I never really thought about. And we've been doing this work for how many years now with no real issues. I mean, we've had some complicated situations that made us, you know, a little nervous, but everything has always worked out just fine. We have rarely had a situation where a client has had to contribute to a settlement, and when that has happened, the client just wanted it over with, and they're like, please, I'm cutting a $50,000 check to bridge the gap, let's be done with this, okay? When I read this rule, it's a definitive rule. It's a shout. There is no interference with the lawyer's independence, professional judgment. So the question to the panel is, you know, when we're dealing with litigation guidelines and complying with litigation guidelines that do impose some restrictions on what you can and cannot, should and should not do to defend a client, are we offending Rule 1.8 with this mandatory language? Anybody ever think about this, have a comment about it?
Sure. And you know what, I've lost my voice, I don't know how. Cigars, alcohol. When you look at the guidelines, that's number one. Number two, if
you would ever run into a situation where you told the carrier, I think we need to do X, and the carrier says, no, then you need to do X. I mean, that's what that rule says.
That's my main question. I've done that.
They could say, no. Now, do they ever? I've never had a carrier say no when I've made a suggestion. But if they say no, you have to do it. There is no interference.
So,
It is still.
but on that point, a lot of times, we get this with an opportunity, especially down in Florida. There are new rules with no continuances, and so you have to front load your case with experts. So we're making recommendations as soon as we're getting the assignments for, liability experts if needed, medical experts, biomechanical if it's that kind of case. And we're still getting pushback. Let's hold off until we try to mediate. And as the lawyer, I told my team, if you get that message, you gotta let me know so I can call and say, not anymore. We cannot hold back. We have to hire these folks now. And so we're still fighting that battle because the landscape has changed a little bit in Florida, but probably not unique to some other states as well. And that, the cost-saving approach is one where I think Jim is saying, I haven't had that happen before. But I think if you consider when they say, hold off on hiring the experts.
I mean, I have
Yeah.
many times, and usually they're telling my associates, because I'm saying, hey, call the carrier, and then they send an email, which I don't know why, they don't use the word call. Call the carrier, and get approved for this, and they come back and say, they won't approve it. And then I get on the phone and say, I'm sorry, we got to do it, and they approve it.
Yeah.
And that's, but it's just the message that we're sending to them, but everybody understands the way things change, sometimes that's
Yeah, and I think too, what you have to consider is, we see on our side where an associate maybe isn't getting as much influence from the partner that they should, and they're a little overzealous, and, we can file a motion on this, and we can, and I'm like, okay, those motions never work, or, right? So there's some practicality that I think the adjusters try to apply, but absolutely, then it's always better as a discussion, right? Here's why we need to do this now. Maybe you want to go ahead and hire the expert because you want that expert, you don't want somebody else to get him, right? I mean, there's that. You want them on your side. So there are a lot of factors to consider in those decisions.
I have, same with working with associates, we have to do these detailed initial reports within whatever, 30 days, 60 days. And I tell them to be very clear in the recommended actions to say, I only want you to say, we recommend if it's something that it's a must, like my kids' teachers do, if it's a must do, and then if it's something that we should consider, we should consider. Because then you're not putting it in writing. So obviously if I have a back surgery case, I'm going to say, I recommend you hire an orthopedic surgeon to do a film and records review potentially at an IME. But in that same case, I may say, we should consider hiring, broad sniffers to do this. Because one is, I know, because I've done a million other cases, the client's going to say absolutely, and the other one, they may say, well, Joe, let's talk.
Yeah. All very reasonable approaches. The fact is, at least in my experience, I haven't had a problem with, doing what needs to be done for the client. And, one of the reasons I think that the folks in this room hire the folks in this room is because we try cases, we know what these cases look like at the end, and we're going to streamline these things, right? We're going to do what we need to do, and we're not going to do what we don't need to do, because there's a lot of that shit going on. And so I think, that's the benefit of having a relationship is that you can talk about these things and you can collaborate and make good decisions. So there is room within the rules to have some parameters without violating the ethical rules. I think that's the sort of the point here. So changing gears a little bit, unauthorized practice of law, something that, you know, I think has become more relevant recently. Where the litigation guidelines become relevant here is how the use of paralegals, right? The use of junior attorneys, for instance, you know, pressing the work down where we can, and understanding that, you know, cost savings and cost management is extremely important. Do we run afoul of the ethical rules when we're requiring lower level staff to do tasks that are traditionally lawyer tasks and more senior lawyer tasks?
Yeah, I'm running into that a lot when the bill reviews come and they'll say, oh, a paralegal should have done this job. And just an example, and actually I learned something, a meet and confer process is different in different states apparently. California, you have to quote meet and confer with opposing counsel before you file like a motion to strike, a demur, things like that, right? So I put, you know, an attorney needs to do that. You can't have a paralegal do that. That's practicing law. So I was the meet and confer with plaintiff counsel regarding, you know, discovery dispute, right? I'm getting deductions, and I get kind of pissed off. I'm like, really? Like I get snarky sometimes in my appeals, and I probably shouldn't. But it's like you're causing us to have somebody engage in the unauthorized practice of law. Like, just reimburse the freaking money, okay? Sorry. We have to, you need the attorney to do that type of stuff.
Well, and I think that gets back to what we talked about, the communication piece.
How do you really feel, Jimmy?
Yeah. That's a communication piece, right? That's getting kicked out. That, again, it's very easily resolved. You know, a meet and confer is something that requires an attorney. You know, person at my level can make sure that's set, that our bill review team understands that, right? I mean, so it's all about communication.
They always, you know, that's just a pain every time. So I guess I should say, meet and confer as required by the court, you know, mandated by the attorney.
I said, attend mandatory attorney meet and confer as required by court order and rules regarding, and no one talks like that, no one writes like that, but the AI machines, that's what they want.
Have you ever gotten your bills deducted by attending an expert deposition without getting written approval first? Well, you know, that's our fault, we should, but the response is, you want me to commit malpractice and not attend the opposing expert deposition?
No one wants you to commit malpractice.
I think what the takeaway here is just pick up the phone.
They just want to talk to you. They just want to talk to you.
Yes. Joe.
Actually, I hate filling out those initial, the initial report that goes through the whole case, what your budget's going to be and all that, but I think that's a really good opportunity to stave off a lot of these problems down the road. If the lawyer who's doing the initial assessment, I don't know what you call it,
Valuation.
not even evaluate, they have good, like, an alphabet soup for some of them. Anyway, initial action plan or whatever.
Action plan.
If you are over-inclusive or as inclusive as you should be, the lawyer, in terms of what you want to do in the case, because we know when we get a case in, what pretty much what's going to be required. There may be some surprises. What experts you need, what depositions you need to take, what investigation, and they're all laid out for you. I hate those reports, but they can really be valuable because then it's all front-loaded, and then you can have the discussion with the claims professional about, what can we take out, what do we really need, that kind of thing. So I think, just at the beginning.
The problem with that, Joe, is the people reviewing the bills aren't the handling adjusters for a lot of people.
But then you can refer back to that, I've actually attached them and said, wait, we had this agreement. Like, I have to sign it, or the claim professional has to sign it electronically or whatever. And then I love including all kinds of documents to the bill review service because it makes them work.
Yeah, and
We're the next time.
But you can't upload, I can't upload on their programs, like more than a couple pages.
Really?
Yeah.
Send them to me.
Sometimes,
I say, oh, I'm happy to send you a Dropbox link. They never once,
sometimes they like require the motion, you have to like send them a motion that you're charging 3.2 hours for, that they said should take 0.4.
right.
They should all copy.
Yeah. Joe, you're right. We are really trying to do more of that in every case, which is this. Laying out our litigation plan, the experts that we want to hire, budgets if we have them, CVs, and start that process right from the beginning, and so that we're not scrambling 6 months, 9 months later when the expert deadlines are coming up trying to get authority. There's lawyers come to us and say, Rick, I need you to jump in here. I've got a week to disclose expert opinions. That should never happen. There is nothing that angers me more than an attorney that doesn't think ahead and plan for the experts that we're going to need. Why not do that at the beginning? Henry, what's your thought on getting all of that information up front? We may not pull the trigger yet, but is there any harm in doing it?
No, not at all. Not at all. I mean, that's why, certainly in our guidelines, I'm sure in most guidelines, that whole purpose of that initial phone call, which people like to kind of skip over, right? Where they hate getting on the phone to call, and they send an email, right? But that's the whole purpose of that. Talk about all those items, so you kind of cover it all up front.
And let me pose this to you, both of you. It's a situation where your client wants you to hire expert A, and you try to get approved, like, no, I'm not gonna hire that company, and the client's insisting. What do you do in that situation?
They can manage it.
Depends on the price.
Vendor arrangement between the carrier and an expert.
Right.
You want me to start?
I mean, yeah, you just talked about one of the rules up there, should not interfere with your professional judgment. And if I, as a lawyer, say, I think, this expert's the best one out there, this is a tough case, we're going up against a top plaintiff firm, we need this guy, client wants him, the carrier says, now we don't want to use that. What do you think, Rick?
Well, I think that, if it's a significant enough case and a significant enough issue, I'm going to push back and I'm going to strongly recommend that we use somebody else. Strong. Very strong. Like double strong on the rock strong. And I haven't had a problem. I've always been able to work this out with the carrier. We have a conversation, and they say, you know what? I'm going to trust your judgment. And, these guidelines have caveats in them that say, these are enforced and what you're required to follow unless they conflict with the ethical rules, right? So everybody is contemplating this. It's just a matter of communicating through the process.
Pick up the phone, everyone's reasonable, and you call Henry up and explain the situation, she's never once said no. Like, I don't need that.
That's right. And I found that, a lot of times the adjusters don't like these, prepackaged vendors or expert firms anyway. And so, there again, just haven't had an issue with it.
It just, when it comes to that, what can occur, we've had situations where that expert, maybe they're a sole practitioner, and then something happens to them. Where's that information? How was it stored? Did they have proper E&O insurance? There are things that come up, surprisingly, in that world that by having vetted vendors, you have confirmed those items are secured and taken care of.
So we are, I believe, approaching our time here. Red, yes? 1 minute? Okay, so really the only thing left that we were going to talk about, and we already have, is bill sharing. So I think we've set the table and we have a good path forward there too.
I will say the biggest area I've seen bill sharing issues come up is a lot of our policies, as I think a lot of liability policies, at least in the construction space, have deductibles. And when it comes to an additional insured, you have some insureds who are good about reviewing their bills and they want to see what is in support, and you have to have that discussion as to why they can't have the legal bill for the additional insured. And that's a conflict, and we would not disclose that. No carrier would or should.
Well, and so as a rule, when we send out our formal acknowledgement, it used to be one paragraph, now it's 3 pages. And it includes such things as we're going to be sharing information with not only a carrier, but a third-party bill auditor. You need to preserve information, and explaining that. And we talk about the tripartite relationship in general. It's all in there, and we don't have them countersign it, and this is probably a good practice, but there is language in there that says, if you have any issues with any of this, please notify us in writing immediately. And we've found that the letter is sufficient. We've conferred with Ethics Council on that letter, and then we're told that it's sufficient. So as long as we're doing these things, as long as the client is informed, then life is good. Any questions? Anyone want to talk about the tripartite relationship anymore?
I feel more ethical already.
You got an hour of ethics, folks. This is good stuff. So thank you.